Hello everyone, I'm delighted to be with you today to talk about Hong Kong's licensing regime for virtual asset trading platforms, which I will at times refer to in this webinar as VATPs, and the recent developments in this space. During the course of today's webinar, I'm going to cover the scope of virtual asset activities that require SFC licensing, the key licensing eligibility criteria, and the ongoing obligations of licensed VATP operators. I'll also be looking at the recent changes to the regime, including the streamlined application process introduced in January 2025 and the SFC's circulars issued in April and August 2025, allowing licensed platforms to stake clients' virtual assets subject to certain conditions and imposing additional obligations on them in respect of their custody of clients' virtual assets. I'll end by looking at the potential consequences of misconduct involving virtual assets, including the various statutory offences. So Hong Kong has two licensing regimes governing VATPs. Platforms that offer trading in virtual assets that are not securities as defined in Schedule 1 to the Securities and Futures Ordinance, the SFO, for example, Bitcoin, must be licensed as virtual asset service providers under the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, which I'll refer to in this webinar as the AMLO. Platforms that provide trading in virtual assets that are securities, on the other hand, need to be licensed under the SFO for dealing in securities and providing automated trading services. Given the possibility that a virtual asset's regulatory classification may change from a non-security to a security or vice versa, the SFC encourages VATPs and their relevant employees to apply for licenses under both ordinances. Applicants can submit a single consolidated application indicating that both licenses are sought. The VATP regime has been in force since June 2023, and according to the SFC's website, there are currently 11 licensed VATPs and a further 18 platforms waiting to hear the outcome of their license applications. Under the AMLO, an entity must be licensed if it carries on a business of providing a virtual asset service, which the AMLO refers to as a VA service, in Hong Kong, or holds itself out as doing so. Licensing under the AMLO is also required for an offshore entity to actively market to the Hong Kong public any service that it provides outside Hong Kong, which would be a VA service if it were provided in Hong Kong. That applies whether the active marketing is conducted by the trading platform itself or another person, for example, a group company. This means that an offshore entity is required to be licensed if it actively markets to the Hong Kong public a VA service that it provides offshore. In practice, however, the SFC will not license offshore entities because they fall outside its regulatory remit. The provision therefore operates to prohibit any offshore VA trading platform from actively marketing its VA trading services to the Hong Kong public. Failure to comply with the AMLO's licensing requirements is an offence which carries maximum penalties of 7 years imprisonment, a fine of 5 million Hong Kong dollars, and a daily fine of 100,000 Hong Kong dollars for continuing offences. According to the SFC's FAQ, examples of active marketing include frequently calling on Hong Kong investors to market services, including offering products and mass media programs and internet activities targeting Hong Kong investors. The FAQ lists various non-exhaustive factors it will consider in determining whether services are actively marketed to the Hong Kong public. These include whether there's a detailed plan to promote the services, whether the services are extensively advertised using direct mailing, adverts or in local newspapers or broadcasting or push technology over the internet, and whether the services are packaged to target the Hong Kong public. For example, by being written in Chinese and denominated in Hong Kong dollars. Providing a VA service is defined as operating a VA exchange, which is defined as providing services through means of electronic facilities whereby offers to sell or purchase virtual assets are regularly made or accepted in a way that forms or results in a binding transaction, or persons are regularly introduced or identified to other persons in order that they may negotiate or conclude, or with the reasonable expectation that they will negotiate or conclude, sales or purchases of virtual assets in a way that forms or results in a binding transaction. The SFC has said that the VATP licensing regime applies only to centralized VA trading platforms that provide virtual asset trading services to clients using an automated trading engine that matches client orders and also provide custody services as an ancillary service to their trading services. The provision of virtual asset services without an automated trading engine and ancillary custody services, for instance, over-the-counter virtual asset trading activities and virtual asset brokerage activities, does not require a license. The SFC and FSTB are, however, currently consulting on new licensing regimes for providers of virtual asset dealing services and virtual asset custodians. There are three strands to the definition of virtual assets. First, virtual assets are a cryptographically secured digital representation of value that are expressed as units of account or a store of economic value. Secondly, the virtual asset must either be used or intended to be used as a medium of exchange accepted by the public for the payment for goods or services, for the discharge of a debt and/or for investment, or must provide rights, eligibility, or access to vote on the management, administration, or governance of the affairs in connection with, or to vote on any change of the terms of any arrangement applicable to any cryptographically secured digital representation of value. The third strand of the definition is that the virtual asset must be transferred, stored, or traded electronically. There are a number of specific exclusions from the virtual asset definition. It excludes digital representations of fiat currencies, such as Hong Kong dollars and US dollars, central bank digital currencies, financial assets already regulated under the SFO, such as securities and futures contracts, and stored value facilities, which are separately regulated under the Payment Systems and Stored Value Facilities Ordinance. The definition also excludes limited purpose digital tokens, which include non-transferable, non-exchangeable, and non-fungible closed-loop limited purpose items, such as air miles, credit card rewards, gift cards, customer loyalty programs, and gaming coins. VATPs that provide trading in virtual assets that are securities within the definition in Schedule 1 to the SFO and provide automated trading services in those virtual assets, or hold themselves out as doing so, must be licensed under the SFO for regulated activities. Type 1, dealing in securities, and Type 7, providing automated trading services. As for the AMLO licensing regime, licenses are only required for centralized VATPs. That's trading platforms that provide trading, clearing, and settlement services for virtual assets and have control of client assets. A license is not required for platforms that provide peer-to-peer trading in virtual assets between clients, where the trades take place off exchange and the clients retain custody of their virtual assets. As under the AMLO, the SFO prohibits an offshore entity from actively marketing to the Hong Kong public any services it offers offshore that would constitute SFO-regulated activities if they were provided in Hong Kong under Section 115 of the SFO. That prohibition applies whether the offshore entity conducts the act of marketing itself or through another person, and whether the act of marketing is conducted from offshore or in Hong Kong. The provision means that offshore VATPs can't actively market their offshore services to the Hong Kong public. What constitutes active marketing is the same under the AMLO and the SFO. While the AMLO and SFO set out the key regulatory provisions for VA trading platforms, the detailed obligations and requirements are set out in various SFC codes, guidelines, and frequently asked questions. Most of the detailed obligations are set out in the SFC's guidelines for VATP operators, which I'll refer to going forward as the VATP guidelines. Licensed VATPs must also comply with the SFC's guideline on anti-money laundering and counter-financing of terrorism for licensed corporations and SFC-licensed virtual asset service providers, while their associated entities must comply with the SFC's Prevention of Money Laundering and Terrorist Financing Guideline for associated entities of licensed corporations and SFC-licensed VASPs. The SFC's also published FAQs on licensing matters and conduct-related matters for licensed platforms. For guidance on the licensing process, you can refer to the SFC's Licensing Handbook for VATP operators, which can be downloaded from the SFC's website. In order to be licensed by the SFC, a trading platform operator needs to be either a Hong Kong incorporated company that has a permanent place of business in Hong Kong, or a company incorporated overseas that's registered in Hong Kong under the Hong Kong Companies Ordinance. Businesses that do not have a separate legal personality, such as partnerships and sole traders, individuals, and overseas companies that are not registered in Hong Kong, are not eligible for licensing as VA trading platforms. The VATP guidelines set out financial resources requirements that licensed platform operators have to meet on a continuing basis. First, they must have at least 5 million Hong Kong dollars of paid up share capital and liquid capital of the higher of 3 million Hong Kong dollars, and the basic amount as defined in Division 2 of Part 4 of the Securities and Futures Financial Resources Rules. They must also beneficially own liquid assets such as cash, deposits, treasury bills, and certificates of deposit, but not including virtual assets that are equivalent to at least 12 months of their actual operating expenses, calculated on a rolling basis. Platform operators must appoint a minimum of 2 responsible officers to supervise their licensed business, who must be approved by the SFC. At least 1 responsible officer must also be an executive director of the company, and if there's more than 1 executive director, they must all be appointed as responsible officers. At least 1 of the responsible officers must be ordinarily resident in Hong Kong, and at least 1 responsible officer must be available at all times to supervise each regulated activity or business. Platforms that are dual licensed under the AMLO and SFO are required to have 2, not 4, dual licensed responsible officers to meet the statutory minimum of 2 responsible officers under each ordinance. The substantial shareholders and ultimate owners of a VATP operator are also required to be fit and proper and must be approved in writing by the SFC. A substantial shareholder is a person with an interest of 10% or more in the platform operator's issued shares, or a person with an interest in the platform operator's shares that entitles them, either alone or with their associates, to control the exercise directly or indirectly of 10% or more of the voting power at its general meetings. A person will also be a substantial shareholder of a VATP operator if they hold shares in another company which entitles them, alone or with their associates, to control the exercise of 35% or more of the voting power at general meetings of the company, or of a further company which can exercise, either alone or with its associates, 10% of the voting power at general meetings of the platform operator. An ultimate owner is an individual who owns or controls more than 25% of the issued share capital of the VATP operator, controls more than 25% of the voting rights at its general meetings, or controls its management. The SFC's FAQs on measures for augmenting senior management accountability in platform operators implement a manager in charge regime based on the requirements for other SFC licensed entities. The requirement is that trading platforms must appoint 1 or more managers in charge as the person principally responsible, either alone or with others, for managing each of the platform operator's 8 core functions. This seeks to ensure that trading platforms' senior management assumes primary responsibility for ensuring the platform has appropriate standards of conduct and that those standards are adhered to. The 8 core functions are: first, overall management oversight, which involves responsibility for the day-to-day direction and oversight of the platform's overall operations and covers developing the platform operator's business model, organizational structure, controls and policies, and developing and monitoring corporate governance practices, culture, and ethics. The second core function is key business line, which is responsible for directing and overseeing a line of business that is a regulated VA service under the AMLO or a regulated activity under the SFO. Operational control and review is the third core function, which is responsible for ensuring effective systems and controls. The fourth core function is risk management, which is responsible for identifying, assessing, and reporting risks arising from the platform's operations. The fifth core function is finance and accounting, which has responsibility for financial reporting and analysis of the platform's operational results and financial position. The sixth core function is information technology, which relates to the platform's computer systems, while the seventh core function, compliance, is responsible for setting policies and procedures for complying with the regulatory requirements in jurisdictions in which the platform operates. The eighth core function is anti-money laundering and counter-terrorist financing, which is responsible for ensuring that effective controls are in place to prevent money laundering or terrorist financing. The managers in charge of the overall management oversight and key business line functions are generally required to be responsible officers of the activities they oversee. They can be located offshore, provided they're accountable to the platform operator. The board of a licensed platform operator needs to ensure that each manager in charge acknowledges their appointment as manager in charge and the particular core function for which they're primarily responsible. Any change in managers in charge must be notified to the SFC within 7 business days of the change. The SFC needs to be satisfied as to the fitness and properness of its platform, its licensed staff, and its substantial shareholders and ultimate owner. The SFC takes various factors into consideration in determining whether a person is fit and proper, including their financial status and solvency, educational or other qualifications and experience, evidence of their competence, honesty and financial integrity, convictions for any money laundering or terrorist financing offences, and other offences involving fraudulent, corrupt or dishonest conduct. Platform operators also have to appoint a complaints officer to deal with complaints and an emergency contact person to be contacted by the SFC. These individuals do not need to be licensed. SFC approval of the premises to be used for record keeping is also required. The premises must be non-domestic premises that are suitable for storing the relevant documents and records. The SFC will normally only approve premises that are located in Hong Kong so that it can exercise its power to inspect a VATP operator's records. The SFC introduced a streamlined licensing process in January 2025 under its circular to new VATPs seeking to be licensed, enhanced licensing process and revamped external assessments. This simplified application process requires 1 external assessment report on the platform's policies, procedures and controls instead of the previous requirement for 2. The first stage of the licensing process requires the submission of a licensing application bundle to the SFC containing copies of the platform operator's written policies and procedures, a copy of the request for a proposal from an external assessor, the external assessor's expression of interest in performing the external assessment, and a capability statement for the external assessor. The SFC will then assess the application, including the VATP license, applicant's business, structure, competence, and the fitness and properness of the applicant, its ultimate controller, ultimate owner, substantial shareholder, proposed responsible officer, and proposed manager in charge, as well as the capabilities of the proposed external assessor. Depending on the circumstances, the SFC may contest or express concerns about the choice of external assessor or otherwise determine that the application is incomplete and/or has unresolved fundamental issues. In these cases, the SFC will return the application to the applicant with reasons for its decision. Once the SFC accepts the application for a VATP license, the applicant must deploy its systems and controls for ensuring compliance with the VATP guidelines and guideline on anti-money laundering and counter-terrorist financing for licensed corporations and SFC licensed VASPs. When the applicant is ready to undergo an external assessment of its policies, procedures, systems, and controls, it needs to enter into a tripartite agreement with an external assessor and the SFC. The licensed applicant must exercise due skill, care, and diligence in selecting and appointing an external assessor and must ensure that it has adequate expertise, technical knowledge, and experience of reviewing and assessing the operations of VATPs and thoroughly understands the regulatory requirements for SFC licensing. The external assessment must be performed as a direct assurance engagement and must be signed off by a practicing certified accountant. The external assessor is required to form an opinion as to whether the license applicant's policy, procedures, systems, and controls are suitably designed and implemented to meet the requirements of the SFC's VATP guidelines and the AML-CFT guidelines. As a party to the agreement, the SFC will oversee the external assessment, provide clarity on regulatory standards, and provide feedback on the assessment's findings. Any findings by the external assessor need to be rectified during the assessment process. The assessment report will then be submitted to the SFC for approval of the license application. If the SFC refuses a licensing application, the applicant will be given the opportunity to be heard, and the SFC will consider the applicant's representations before making a final decision. If the SFC then proceeds to refuse the application, the applicant has a right to apply for a review of its decision to the Anti-Money Laundering and Counter-Terrorist Financing Review Tribunal and the Securities and Futures Appeals Tribunal. The SFC imposes a number of conditions on VATP licenses. These include requirements that the platform operator complies with the VATP guidelines and immediately notifies the SFC and ceases operating if it cannot maintain or ascertain whether it maintains the required amounts of liquid capital and paid-up share capital. The licensing conditions also require VA trading platforms to provide the SFC with monthly reports on their business activities within 2 weeks of the end of each calendar month and any other information requested by the SFC. Licensed platforms must also engage an independent professional firm acceptable to the SFC to conduct an annual review of their activities and operations and prepare a report confirming that they have complied with the licensing conditions and all relevant legal and regulatory requirements. The first report must be submitted within 18 months of the platform operator's licensing, and subsequent reports must be submitted within 4 months of the end of each financial year and on request by the SFC. Under the licensing conditions, VATPs must obtain the SFC's written approval before introducing or offering a new or incidental service or activity or making a material change to an existing service or activity, including the long suspension or termination of an existing service or activity. The licensing conditions also restrict trading platforms to operating a centralized online platform for trading virtual assets, although they can conduct off-platform virtual asset trading business and services and activities that are incidental to their off-platform business. SFC-licensed VATP operators must set up a token admission and review committee made up of members of senior management who are principally responsible for managing the platform's key business line, compliance, risk management, and information technology functions. The SFC expects members principally responsible for the various functions to include the corresponding managers in charge of the platform operator. The responsibilities of the Token Admission and Review Committee include establishing, implementing, and enforcing the criteria for admitting, suspending, and withdrawing virtual assets for or from trading and the rules containing the obligations and restrictions on virtual assets. The committee is also responsible for making the final decision as to whether to admit, suspend, and withdraw a virtual asset for clients to trade based on the adopted criteria. These criteria and rules must be regularly reviewed by the committee. It must also report at least monthly to the board of directors of the VA trading platform operator, and its reports must, at a minimum, include details of the virtual assets made available to retail clients for trading. Hong Kong licensed VATPs are required to monitor each of the virtual assets admitted for trading on an ongoing basis and consider whether to continue to allow them to trade. Regular review reports are required to be submitted to the Token Admission and Review Committee. If the committee decides to suspend or withdraw a virtual asset from trading, the platform operator must notify clients as soon as practicable, inform clients who are holding virtual assets of the options available, and ensure that clients are fairly treated. The VATP guidelines make a trading platform senior management primarily responsible for ensuring that the trading platform and its associated entity have appropriate standards of conduct and procedures in place for their employees, and that their employees adhere to those standards and procedures. In particular, senior management is responsible for ensuring that effective policies and procedures are in place to identify and manage the risks associated with the business of the trading platform and its associated entity. The term senior management refers to a platform operator's directors, responsible officers, and managers in charge of core functions. Before admitting any virtual asset to trading, licensed trading platforms must perform reasonable due diligence on them to ensure that they meet the token admission criteria set by their token admission and review committee. Platform operators have to conduct due diligence on the background of the virtual assets management or development team or any of its known key members and the virtual assets regulatory status in Hong Kong and whether that would affect its regulatory obligations. They must also assess supply and demand for the virtual asset, its maturity and liquidity, including its track record period, which must be a minimum of 12 months for virtual assets that are not securities. This effectively prevents platforms from offering ICO tokens for trading. Platform operators must also consider the market and governance risks associated with the virtual asset and legal risks associated with the virtual asset and its issuer. Virtual assets that are to be made available for trading by retail investors must additionally meet the specific token admission criteria set out in paragraphs 7.7 and 7.8 of the VATP guidelines. Retail investors are defined in the guidelines as persons other than professional investors as defined in the SFO. The key requirement is that the relevant virtual asset must be highly liquid. For a virtual asset to be considered highly liquid, it must be an eligible large cap virtual asset, that is, a virtual asset that is included in a minimum of 2 acceptable indices issued by at least 2 independent index providers. An acceptable index is an index with a clearly defined objective to measure the performance of the largest virtual assets in the global market. For example, an index which measures the top 10 largest virtual assets, which is investable, which means that the constituent virtual assets must be sufficiently liquid and objectively calculated and rules-based. The index providers must have the necessary expertise and technical resources to construct, maintain, and review the methodology and rules of the index, which need to be well documented, consistent, and transparent. The 2 index providers have to be independent of each other, the VATP operator and the issuer of the virtual asset. In addition, at least one of the index providers must comply with the IOSCO principles for financial benchmarks and have experience of publishing indices for the conventional securities market. Noting that large market cap does not necessarily correlate with high liquidity, the SFC has said that inclusion in 2 acceptable indices is a minimum criterion rather than the sole criterion for virtual assets to be eligible for trading by retail investors. Trading platform operators are therefore expected to conduct additional due diligence to ensure that eligible large cap virtual assets admitted for retail trading are in fact highly liquid. Trading platform operators are also required to ensure that a virtual asset being admitted for retail trading is not a security, as defined in Part 1 of Schedule 1 to the SFO, unless the virtual asset offering to retail investors complies with the Hong Kong regulatory requirements for public offers of shares and debentures under the Companies Winding Up and Miscellaneous Provisions Ordinance and does not breach the restrictions on offers of investments under Part 4 of the SFO. The SFC's prior written approval is required for the admission of any virtual asset for trading by retail clients and for the removal or suspension of a virtual asset from retail trading. If a licensed platform operator wants to make available for retail trading a virtual asset that fulfills the general token admission criteria, but not the specific token admission criteria, it can make a submission to the SFC, which the SFC will consider on a case-by-case basis. The SFC stated in its consultation conclusions on virtual asset platforms that platforms should not admit stablecoins for retail trading until they are regulated in Hong Kong. A licensing regime for stablecoin issuers came into effect under the Stablecoins Ordinance on the 1st of August 2025 in Hong Kong. Under the Stablecoins Ordinance, only stablecoins issued by licensed stablecoin issuers can be offered to retail investors. Under the VATP guidelines, platform operators have to implement a number of measures when providing trading for investors who are not institutional professional investors or qualified corporate professional investors. Institutional professional investors are defined in paragraphs A to I of the definition of professional investors in Schedule 1 to the SFO. Qualified corporate professional investors are corporate professional investors, that is, a trust corporation or partnership within sections 4, 6, or 7 of the Securities and Futures Professional Investor Rules, which the licensed platform operator has assessed to meet certain criteria. The first of these criteria is that the corporate professional investor must have an appropriate corporate structure and investment process and controls for making investment decisions. The second is that the persons making investment decisions on its behalf must have sufficient investment experience. And the third criteria is that the corporate professional investor must be aware of the risks involved, which needs to be considered in terms of the persons who make investment decisions on its behalf. The platform operator's assessment of whether a corporate professional investor is a qualified corporate professional investor must be in writing, and the platform operator must keep records of all relevant information and documents obtained in the assessment to demonstrate the basis of its assessment. Platform operators need to undertake a new assessment if a corporate professional investor has not traded virtual assets for more than 2 years. These provisions mean that platform operators must treat individual professional investors, that is, individuals with investment portfolios worth 8 million or more, and corporate professional investors that are not qualified corporate professional investors in the same way as retail investors. Hong Kong licensed VATP operators are not allowed to offer, trade, or deal in virtual assets futures contracts or related derivatives. However, in the SFC's February 2025 regulatory roadmap for virtual assets, the SFC stated that it's considering allowing licensed VA trading platforms to provide trading in virtual asset derivatives for professional investors only. The other main restrictions on licensed VATP operators are that they and their group companies are prohibited from providing any financial accommodation for clients to acquire virtual assets. This prevents them from offering margin financing to their clients. Licensed platforms are also prohibited from entering into arrangements with their clients to use their clients' virtual assets to generate returns. This prevents licensed trading platform operators from providing services such as earning, deposit taking, lending, and borrowing. As I'll talk about later, in April 2025, the SFC issued a circular stating that it will allow licensed VATPs to stake virtual assets for clients, although they must seek the SFC's prior approval and comply with additional conditions that are imposed on the licenses of platforms permitted to provide staking services. The SFC has also said in its February 2025 roadmap that it is considering allowing the provision of virtual asset borrowing and lending for professional investors. Licensed platforms are also prohibited from offering client gifts other than a discount to fees or charges for trading any specific virtual asset. Licensed platforms are not allowed to post adverts for a specific virtual asset. They are also prohibited from providing algorithmic trading services to clients and from conducting proprietary trading for their own account or any account in which they have an interest, except for off-platform back-to-back transactions where no market risk is taken by the platform operator. Licensed platforms are also prohibited from conducting market-making activities on a proprietary basis, and their group companies are prohibited from conducting proprietary trading in virtual assets through the platform operator on or off platform. Platform operators are not allowed to open multiple accounts for a single client, except sub-accounts. Platform operators must obtain the SFC's written approval before offering any virtual asset for trading by retail clients, and before suspending trading of or removing from trading any virtual asset available to retail clients. Before opening an account for investors other than institutional professional investors and qualified corporate professional investors, trading platform operators must assess their knowledge of virtual assets and of the risks involved in investing in them. Trading platform operators can only open an account for or provide services to investors who lack knowledge of virtual assets if they have provided adequate training to the investor. The VATP guidelines set out non-exhaustive criteria for assessing whether an investor can be regarded as having knowledge of virtual assets. These are whether the investor has undergone training or attended courses on virtual assets, or has virtual asset-related work experience or prior trading experience in virtual assets. For clients other than institutional investors and qualified corporate professional investors, VA trading platform operators must also assess clients' risk tolerance level and determine their risk profile and whether they are suitable to trade virtual assets. Clients' risk profiles need to be determined based on an assessment of their financial situation and investment experience and objectives. Except for institutional and qualified corporate professional investors, VA trading platform operators must also set a limit on each client's exposure to virtual assets to ensure that the client's exposure to virtual assets is reasonable given the client's financial situation, including their net worth and personal circumstances. Platform operators must notify these clients of the limit assigned to them and must regularly review clients' exposure limits to ensure they remain appropriate. When making a recommendation or solicitation with respect to virtual assets, platform operators must ensure the recommendation or solicitation is suitable for the client, having regard to information about the client of which the platform operator is or should be aware through due diligence. This suitability requirement does not apply when dealing with institutional and qualified corporate professional investors. Platform operators need to establish a proper mechanism for assessing the suitability of virtual assets for clients. The suitability assessment needs to be made on a holistic basis, taking into account the client's personal circumstances and concentration risk, and the risk-return profile of the recommended virtual asset should match the client's personal circumstances. Except when dealing with institutional and qualified corporate professional investors, VATP operators must prominently disclose the nature of virtual assets and the risks associated with trading them. Disclosure must include the risk disclosure statements specified in Schedule 2 to the VATP guidelines. VATP operators must disclose on their websites information about the platform's businesses, the services it offers, and its contact details. They must also disclose their trading and operational rules and token admission and removal rules and criteria. These must also include the criteria for admitting, suspending, and withdrawing a virtual asset to or from trading, and the acceptable indices referenced for admitting virtual assets for retail trading. All admission and trading fees and charges must be displayed, and disclosure is required of services that are only available to professional investors. Websites must also disclose the rights and obligations of the platform operator and the client under the client agreement that clients other than institutional and qualified corporate professional investors must enter into. Other matters requiring disclosure include the client's liability for unauthorized virtual asset transactions, situations where the platform operator can disclose the client's personal information to third parties, including regulators and auditors, and the available dispute resolution mechanisms, including the complaints procedure. Licensed platform operators need to post information about each virtual asset traded on their platforms. That information includes the virtual asset's price and trading volume on the platform, for example, in the last 24 hours and since its admission for trading on the platform, background information about the virtual assets management or development team or any of its known key members, the virtual assets issue date and its material terms and features, the platform operator's affiliation with the issuer and its management or development team or any of its known key members, a link to the virtual assets official website and any white paper, a link to any smart contract audit report and other bug reports, and if the virtual asset has voting rights, how those voting rights will be handled by the platform operator. Platform operators need to take all reasonable steps to ensure that product-specific and other information posted on their platforms is not false, misleading, or deceptive. They are also required to disclose their financial condition on request to clients by providing their latest audited balance sheet and profit and loss account filed with the SFC, and any material changes adversely affecting their financial condition since the date of the accounts. A licensed VATP operator can only hold client assets, that is, client virtual assets and client money, through an associated entity. An associated entity is a Hong Kong incorporated subsidiary of the VATP operator, which is a licensed trust or service company provider under the AMLO, which has notified the SFC that it is an associated entity of the licensed VATP operator under Section 53ZRW of the AMLO and Section 165 of the SFO. The associated entity is not allowed to conduct any business other than that of receiving or holding client assets on behalf of the trading platform operator. Client virtual assets must be held in wallet addresses established by the platform operator's associated entity and must be segregated from the assets of the platform operator and its associated entity. At least 98% of client virtual assets must be held in cold storage, which is less vulnerable to hacking and other cybersecurity risks, except in limited circumstances allowed by the SFC on a case-by-case basis. Licensed trading platform operators must have robust internal controls and government procedures to ensure that cryptographic seeds and private keys are securely generated, stored, and backed up. They must also ensure that their associated entities implement the same controls and procedures, which must, among others, restrict access to seeds and private keys for client virtual assets to authorized personnel who've been appropriately screened and trained, and provide for seeds and private keys to be securely stored in Hong Kong. In the wake of financial losses suffered by overseas VATPs due to cybersecurity incidents, the SFC imposed additional virtual asset custody requirements on licensed VATPs and their associated entities on the 15th of August 2025 in its Circular on Licensed Platform Operators' Custody of Virtual Assets. The circular requires platform operators to designate at least one responsible officer or manager in charge to oversee the custody arrangements required under the circular. It also emphasizes the senior management's responsibility for ensuring that effective policies, procedures, and internal controls are implemented, and that these are monitored by qualified and experienced members of senior management. The circular adds new requirements for platform operators to conduct due diligence when selecting providers of hardware security modules, to generate, store, and back up cryptographic seeds and private keys, and perform regular ongoing assessments of them to ensure they remain reliable. In particular, platform operators must ensure the vendor's ability to maintain security standards through patch management, to protect virtual asset deposits and withdrawals from fraud and theft. Seed and private key generation and storage must occur on air-gapped cold wallet devices, that is, wallets that are not linked to the internet. Multi-layer security checks must be put in place across each phase of transactions, and clear role segregation is required. Effective controls must be implemented to block unauthorized cold wallet transactions. The key measures required include whitelist controls to prevent transfers to unapproved wallet addresses, controls and oversight of changes to the cold wallet whitelist, and automatic verification of transactions to confirm their legitimacy. When selecting third-party wallet solution providers, VATP operators must perform thorough due diligence of the provider and continuously monitor the provider's compliance with the VATP guidelines after selection. This includes regularly assessing the provider's security controls, operational protocols, incident reporting practices, and regularly testing its disaster recovery readiness. The new circular also imposes requirements relating to ongoing real-time threat monitoring and staff training. In particular, Transaction signers must receive comprehensive training to fully understand the verification requirements and appropriate procedures in cases of uncertainty concerning a transaction, and controls must be implemented to prevent blind signing and ensure effective reviews or approvals of manual transactions. The SFC stated in the circular that once these new minimum standards for VA custody are met, it will consider allowing VATPs to transition to more advanced custody technologies, as alluded to in its February 2025 roadmap for virtual assets. These custody standards will also form the baseline compliance criteria for SFC licensed virtual asset custodian service providers on implementation of the proposed licensing regime that is currently under consultation. Licensed VATP operators must have compensation arrangements to cover potential losses due to hacking incidents or default on the part of the licensed platform operator or its associated entity. These arrangements must be approved by the SFC. The compensation must cover 50% of client virtual assets held in cold storage and 100% of client virtual assets held in hot and other storages. Compensation arrangements can include any or a combination of third-party insurance, funds held in the form of a demand deposit or time deposit maturing within 6 months of the platform operator or any of its group companies, which are set aside on trust and designated for that purpose, and a bank guarantee provided by a bank regulated in Hong Kong. Licensed platform operators must also monitor the total value of client virtual assets under their custody daily. If a licensed platform operator becomes aware that the total value of client virtual assets under custody exceeds the amount covered under the approved compensation arrangement, and it expects this to continue, it must inform the SFC and take prompt remedial action to recomply with the VATP guidelines. Platform operators must comply with the AML and CFT requirements of the AMLO, including the customer due diligence and record-keeping requirements set out in Schedule 2 to the Ordinance. Non-compliance with the statutory AML and CFT obligations is an offence, and both the VATP and its responsible officers are potentially subject to maximum penalties of a 1 million Hong Kong dollar fine and 2 years imprisonment or 7 years imprisonment if the non-compliance is committed with intent to defraud. Trading platform operators must also comply with virtual asset-specific AML CFT requirements set out in Chapter 12 of the Guideline on Anti-Money Laundering and Counter-Financing of Terrorism for licensed corporations and SFC licensed VASPs, in addition to the Guideline's general AML CFT requirements applicable to SFC licensed entities. The Prevention of Money Laundering and Terrorist Finance Guideline, issued by the SFC for associated entities of licensed corporations and SFC licensed VASPs, requires associated entities of trading platform operators to comply with the same obligations as the platform operator. VATPs are required to comply with the FATF's travel rule in relation to virtual asset transfers. Very briefly, the travel rule imposes obligations on a trading platform acting as an ordering institution on a virtual asset transfer to another licensed trading platform. Before making the transfer, the ordering trading platform must obtain and record information about the originator of the transfer, including the originator's name and account number and the recipient's name and account number with the beneficiary institution. The ordering institution must submit this information to the beneficiary institution. On receipt of the virtual asset transfer, the beneficiary institution must check that it has received the required originator and beneficiary information and validate the received information by checking that the beneficiary's details matches its customer. Licensed platform operators must also conduct due diligence on virtual asset transfer counterparties to identify and assess the money laundering and terrorist financing risks and apply risk-based AML CFT measures. The detailed requirements are set out in Chapter 12 of the SFC AML CFT guideline and also include obligations for institutions acting as intermediaries. The AMLO requires a VATP to appoint an auditor and notify the SFC of its financial year-end within 1 month of the grant of its VATP license. It must notify the SFC of the auditor's name and address within 7 business days of their appointment. The same requirements apply to a platform's associated entity, that is, its Hong Kong incorporated wholly owned subsidiary that receives and holds client virtual assets. The time frame for an associated entity's obligations is 1 month from when it becomes the platform operator's associated entity. Both the trading platform and its associated entity must file their audited financial statements with the SFC within 4 months of the financial year end. Platform operators must submit monthly financial returns to the SFC within 3 weeks of the month end. Those financial returns must include the platform operator's liquid capital computation and a summary of its debt and an analysis of its client assets at the month end and an analysis of its profit and loss account. The SFC's prior approval is required under the AMLO for certain changes, including, amongst others, a change of financial year, cessation of business, the use of new premises for record keeping, and a person becoming a substantial shareholder or an ultimate owner of a VATP operator. Application for approval is generally made on Form VA2, except for approval of changes to the licensed entity's substantial shareholders and ultimate owners, for which Form VA4 should be used. The VATP guidelines also require VA trading platform operators and their associated entities to immediately notify the SFC of various matters. These include any material failure or defect in the platform operator's or its associated entities' trading, custody, clearing and settlement or accounting systems, and any material breach or suspected material breach of the AMLO, the SFO, or any SFC regulatory requirements, including under the VATP guidelines. The SFC must also be notified immediately of any insolvency-related matter affecting the platform operator, its associated entity, substantial shareholder, or ultimate owner. The VATP guidelines additionally set out various events that must be notified to the SFC within 7 business days. These include a person ceasing to act as a licensed representative or a responsible officer, a change in the name of a VA trading platform operator, and a change in the business address of a VA trading platform operator or its associated entity. Notifications, regulatory filings, and annual returns should all be submitted through the SFC's WINS website. In April 2025, the SFC issued a circular setting out the conditions it will impose on the licenses of VATPs that are permitted to provide virtual asset staking services to their clients. Previously, trading platforms were prohibited from staking client virtual assets, that is, providing arrangements that allow their clients to receive returns from locking or committing their virtual assets so that a validator can participate in blockchain protocol's validation process that's based on a proof-of-stake consensus mechanism. SFC approval is required before a licensed trading platform offers staking services. The conditions that the SFC will impose on the platform's license are set out in Appendix 2 to the SFC's circular on staking services provided by VATPs. The conditions require that the licensed platform retains full control over the withdrawal mechanism for the staked client virtual assets at all times. Client virtual assets cannot be held by external service providers. Platforms must implement controls to prevent fraud and unauthorized activities and must have clear operational rules governing the staking processes. Platforms must obtain an acknowledgement from retail clients that they understand the risks involved before providing staking services to them. In addition, a dedicated committee must establish and review the criteria for selecting blockchain protocols. Platforms can only provide staking services to their own clients. The SFC also issued a circular allowing SFC-authorized funds investing in virtual assets to stake their virtual assets with licensed trading platforms. SFC-licensed virtual asset trading platform operators are required to implement a continuous education program for their licensed employees. Licensed platforms need to confirm their compliance with the CPT requirements when they file their annual returns and must assess their annual training programs. Responsible officers need to complete 12 CPT hours per calendar year, including 2 CPT hours on regulatory compliance, while licensed representatives have to complete 10 CPT hours per calendar year. Training programs can be designed to suit the platform's size, scope of business activities, and risk management system. The AMLO creates various offences in relation to activities in virtual assets that are not securities. First, making a fraudulent or reckless misrepresentation to induce an acquisition or disposal of a virtual asset is an offence, whether the transaction takes place on a licensed VATP or not. The offence under Section 43ZRG of the AMLO carries maximum penalties of a 1 million Hong Kong dollar fine and 7 years imprisonment. It's also an offence in a transaction involving virtual assets for a person to employ any device, scheme, or artifice with intent to defraud or deceive or engage in any fraudulent or deceptive act, practice, or business under Section 53ZRF of the AMLO. The maximum penalties for this offence are a 10 million Hong Kong dollar fine and 10 years imprisonment. Finally, it's an offence under Section 53ZRE to issue an advertisement that an unlicensed person is prepared to provide VATP under the AMLO services. The offence carries sanctions of a 50,000 Hong Kong dollar fine and 6 months imprisonment. There are comparable offences under the SFO in relation to the same conduct in virtual assets that are securities within the statutory definition. First, it's an offence under Section 107 of the SFO to make any fraudulent or reckless misrepresentation to induce another person to deal in securities, which includes acquiring, disposing, and subscribing for securities. Any person found guilty of this offence is potentially liable to a maximum fine of 1 million Hong Kong dollars and up to 7 years imprisonment. It's an offence under Section 300 of the SFO for a person in a transaction involving securities, including an offer or invitation, however that's expressed, to employ any device, scheme, or artifice with intent to defraud or deceive or engage in any act or practice which is fraudulent or deceptive. An offence under Section 300 is punishable by a fine of up to 10 million Hong Kong dollars and imprisonment for up to 10 years by virtue of Section 303 of the SFO. A further offence exists under Section 103 of the SFO, which prohibits the issuance of any document inviting the Hong Kong public to acquire or subscribe or underwrite securities, unless the document has been authorised by the SFC or an exemption applies. The exemptions most commonly relied on include those for invitations for securities that will only be sold to professional investors or overseas investors. The penalties for a breach of this provision are a $500,000 fine and up to 3 years imprisonment. Section 53ZR5 of the AMLO and Section 1932 of the SFO further provide that responsible officers and persons involved in the management of licensed VA trading platforms must also be found guilty of misconduct and thus liable to disciplinary sanction if the licensed trading platform's misconduct occurred with their consent or connivance or was attributable to neglect on their part. The SFC has extensive powers to discipline licensed VATPs, their licensed representatives and responsible officers, and persons involved in their management, irrespective of whether they are licensed. Misconduct is defined broadly to include a breach of any provision of the AMLO or SFO, a breach of the terms or conditions of a person's license, and any act or omission which the SFC considers to be contrary to the interests of the investing public. The sanctions that the SFC can impose include a public or private reprimand and a fine of up to the greater of 10 million Hong Kong dollars or 3 times the amount of profit gained or loss avoided by the person as a result of their misconduct or the conduct which led the SFC to believe that they were not fit and proper to be licensed. The SFC can also revoke or suspend the license of a licensed trading platform or licensed representative and revoke or suspend a responsible officer's approval. The SFC can also order a person to remedy their breach of the relevant ordinance and may ban a person from reapplying to be licensed. Section 53ZTH of the AMLO and Section 213 of the SFO allow the SFC to apply to the Court of First Instance for various orders against a person who has breached any provision of the relevant ordinance, any condition of their SFC license, or any other conditional requirement imposed or notice given under any provision of the relevant ordinance. The AMLO additionally allows the SFC to apply for orders against a person who has breached any provision of any code or guideline published under the AMLO, which would include a breach of the VATP guidelines. The SFC tried to include a similar provision in the SFO to allow it to seek orders, including orders for the payment of compensation against a person in breach of the various SFC codes, including the Code of Conduct for persons licensed by or registered with the SFC. The SFC, however, dropped that proposal in the face of widespread opposition from the market, which had concerns regarding the courts being able to impose legal remedies for breaches of SFC codes and guidelines which are non-statutory. The orders that can be made by the SFC include injunctions for the relevant person to take or refrain from taking a specified action. These can include a restoration order to put the other party to the transaction back to the position they were in prior to the transaction. In instances under the SFO, the SFC has been successful in obtaining orders for the licensed party to compensate counterparties for the loss they suffered due to the licensed party's misconduct. The court can also declare a virtual asset transaction to be void. The SFC can seek orders not only against the person who's committed the relevant breach, but also against others who have, for example, assisted or conspired with the wrongdoer to commit the breach or been knowingly involved in its commission. So that brings us to the end of today's webinar. Thank you again for joining me, and I hope you enjoyed the webinar. See you again. Bye.